60.
One check.
Council protect. Okay. Yes.
May I please, Your Lordship? Lordship, on last occasion, Your Lordship has asked me to obtain the instruction in respect of item number 52 of supplementary list, whether the parties are willing to go for mediation or not,
Right.
Lordship. So I have obtained the instruction, Lordship. I am for the petitioner, Lordship. They are willing to go for the mediation, Lordship.
We'll pass the order.
I am for the petitioner, Lordship.
We'll pass the order at 2 o'clock.
Lordship.
We here at 2.
Lordship. Oblige, Lordship.
I recommend the item number 23 also.
23.
Yes. Yesterday I filed an additional letter with the. That's why we checked the record.
Yes.
May I please, Lordship. Lordship, with the consent of other side, my lord, I beg to mention item number 6, my lord.
Yes.
Lordship, the learned counsel, Mr. G. Deka, my lord, is due to Shraddha ceremony from his of his house, my lord. He could not come to my lord.
Yes.
There is, my lord, interim, my lord. Interim may be complete.
After we next date of this. Yes.
Positive.
I wish to mention item number 5. Due to my senior's medical issue, Lordship, I have for an adjournment.
On the prayer of council for the 5, right?
5.
Yeah.
Lordship, there is the interim order.
3 weeks. Till the next. Yes.
May I please, Lord? Sir, I'm praying for listing of a matter for hearing, Lord, a criminal petition, Lord.
Not come stating for hearing.
Lord, it's a maintenance matter, Lord. I'm for the wife.
It has
Lordship.
to come for orders first. Then only a date of hearing can be taken.
Okay, then Lordship will list it for orders. Lord. On 20, Lordship.
For orders on 19.
19.
Yes, Mr. Deka.
With the consent of the petitioner, council,
Hmm.
after 2 weeks, no. But 2.
Have you informed the other side?
Yes, the second council.
May I please?
What is the orders matter? Why has been listed for orders? Any idea, Mr. Deka? Just wait for a few minutes. We'll finish the
Well-
mentioning. We'll see what is it.
May I please, Lordship? Lordship, I wish to mention item number 9, Lordship. My senior is out of station for medical treatment. Lordship,
Hmm.
kindly listing the matter after 1 week, Lordship.
The Learned Counsel for the petition, Mr. M.M. Rahman. Out the state for his medical treatment. Yes, next.
Oblige, Lord.
Yes. Just a minute. We'll pass.
May it please your lordship, I beg to mention item number 33, as the engaged legal aid counsel is out of station.
Who is the engaged legal aid counsel
Mr. S. Biswas.
for the petitioner?
Yes, lordship.
2 weeks. Will get to be fixed by the next.
Lordship, can it be fixed day after tomorrow?
Tomorrow. On 14th.
Oblige.
Lordship, I am requesting for the urgent listing of matter criminal petition 102/24 for this Friday.
What is the urgency?
There is apprehension of arrest. The police is trying to arrest the petitioner.
Why? Was there any order of
The
NBW?
nature is of NDPS matter.
Okay, on 9th.
online. Thank you.
Yes.
May I please, your lordship? This is a criminal revision petition for listing of orders. Your lordship may kindly list this matter on 9th of August.
What is the urgency, ma'am?
I think,
When it was last listed?
last listed on 12/6/2024.
Okay, on 9th. Yes, Mr. Upadhyay.
God bless you, lordship.
Your lordship, please. Item number 4, my lord, I may be allowed to withdraw. Yes. And withdraw, it may be closed.
Okay, we'll take
Item
care.
number
Just
4.
a minute. Let the mention be over. We'll pass the order. Wait for a few minutes. Yes, ma'am.
May it please, your lordship, also I beg to mention the criminal petition for listing, lordship. Matter is pending for a long period of lordship.
It is for admission or for orders?
Orders, lordship. Matter will be listed on next week, lordship.
Okay, on 14th.
14.
Take our-
I also present. Lordship. Scan copy for the CD, Lordship, about to be not received. No? It was office note on the 10th of October 2014.
Here is the office note. 10/10/2023. In spite of reminders to the learned session judge Nagaon, as well as the officer in charge of Nagaon Sodor Police District. Registry is yet to receive legible scan copy of case diary of Nagaon, in bracket S, PS case number 3101/2019. Registry shall forthwith intimate the learned session judge as well as the officer in charge of Nagaon SPS case. That's it. For the eligible scan copy. Fixed on 38. Failing of the failing on the part of the hearing officer to furnish the relevant records is sought for. In terms of the order of the court dated 28/06/2022, the court shall consider to pass consequence of order. A copy of this order shall also be furnished to Mr. P. Sharma, learned additional public. That's all. For it necessary. Just a copy.
Deeply obliged.
Yes, Mr. Upadhyay. And Mr. P. Upadhyay, learned counsel for the petition. Mr. Paul. Yes, sir. Yes, Paul. Learned counsel for this response. Agree with the Impugn judgment and order dated 09/05/2023. Passed by London Principal Judge, Family Court, Nalbari, in FC case number within bracket 125 seconds, bracket 130 of 2021, whereby the petitioner was directed to pay rupees 4,000 per month to the sole respondent towards maintenance allowance of their minor child from the date of passing of the said order dated 9/5/2020. The petitioner prepared this criminal dividend petition on 10/8/2023. On instruction of the petitioner, Mr. P. Upadhyay and his counsel, Mr. P. Upadhyay, is not pressing this criminal revision petition. According to this sentence.
May I please, my lord, this is a petition that has been filed in booking 401 as well as 482 of the CRPK. May I please, my lord, by this application, my lord, I am challenging an order dated 15/3/2022, passed by the Learned Session Judge, Bongaigaon. Now, my lord, before I come directly to the order, my lord, I would like to give a brief account of this case. Originally, my lord, the present petitioner has filed a proceeding under section 138 of the Negotiable Instrument Act before the CGM court, Bongaigaon. Thereafter, he was held to be convicted by the Learned Trial Court. Thereafter, my lord, he went to appeal. And while admitting the appeal, first, my lord, the Learned Appellate Court passed an order. My lord, may kindly come to page 58 of my petition. This is the order passed by the Learned Appellate Court while admitting.
58.
58, my lord.
Hmm.
May I read, my lord? Order. Seeing the appeal against judgment and order dated 10/1/2020 passed by the Learned CGM Bongaigaon in NICR case number 34/2018, sentencing the accused appellant to undergo simple imprisonment of 3 years along with the compensation 13,10,000 in default SI for 1 month for committing an offence under section 138 of Negotiable Instrument Act. Seeing the memo of appeal along with the certified free copy of the judgment and order passed by the court below. Learned counsel for the respondent is also present. Heard the rounded counsel for the appellant. Case record reveals that the appeal was filed in time. The ground mentioned in appeal memo of appeal are good grounds for appeal. Hence, the appeal is admitted for hearing. Appellant is directed to pay 20% of the fine amount awarded by the court below within 16 days from the date of admission of this appeal. Now, my lord, by this order, the court has admitted the appeal for hearing, and thereafter there is a further direction to the respondent, who happened to be the accused in the original case, to pay 20% of the compensation amount. Now, my lord, under 148 of the Negotiable Instrument Act, the statutory period for submission of that particular 20% amount is usually up to 60 days. But if somebody is unable to pay the amount within the statutory period, then a 30 days time may be further extended to him to pay the amount. This is the law, my lord. I will come to this section. But this order has been passed, my lord, on 22/2020. Now, my lord, may kindly come to the subsequent order, that is Annexure 5 at page 59, order dated 15/3/2022. My lord, while almost for a year, when the respondent accused did not pay the compensation, 20% of the compensation amount, then we have to file a petition intimating the court that he did not deposit the 20% of the amount. I will be allowed. My lord, may kindly come to page 60. I'm reading the last part of this particular order. I have gone through the aforesaid judgment. The deposit of 20% check was not the condition precedent for vacating the order of the stay, order of suspension of the stay. There is no there is no provision to the dismissal of the appeal, and if the said amount is not paid within 30 days, hence I do not find any merit in the petition and same is accordingly dismissed. Now, my lord, there are some judgment passed by the Honorable Apex Court where it has been specifically held that compliance to the 148 of the Negotiable Instrument Act is mandatory in nature, my lord. One cannot avoid paying the 20% or above, whatever amount or whatever percentage that is fixed by the learned appellate court, that has to be paid. And that is subject to the admission of appeal, my lord. Now, this order is an outcome of a petition. My lord may kindly come to page 61. This is the petition that has been filed before the Honorable Apex Court. My lord, this is a very short petition that has been filed. I'm reading it.
Which
The
page?
appeal was admitted on 28th,
Which page?
my lord.
Page.
Page 61, my lord. Page 61.
Petition.
This is the petition that has been filed by the petitioner, my lord. The appeal was admitted on 28/2/2020 on condition that the appellant will pay deposit 20% of the awarded compensation amount in favor of the respondent within 60 days. It is humbly submitted that the appellant has not deposited the said 20% compensation amount till today. In view of above, it is prayed that due to non-compliance of the order dated 28/2/2020 passed while admitting the appeal by this honorable court, the appeal may be dismissed to meet the ends of justice. My lord, under normal circumstances, if somebody does not pay the directed compensation amount, then normally appeal cannot be dismissed, my lord.
Yes.
Now, my lord, if somebody does not pay the compensation amount, appeal cannot be dismissed because a right to appeal under 378 of the CRPC is a statutory right, my lord. That cannot be interfered by the appellate court. But what appellate court can do is to vacate the stay if there is any order that has been passed by the appellate court to suspend the sentence that has been passed by the trial court. In this case, my lord, whereas I have prayed for the dismissal of the appeal, but the learned trial court, in the last part of its order, it is specifically stated that the deposit of 20% of the check amount was not the condition precedent of vacating the order of suspension of stay.
Kindly come to page number
59.
My lord,
58.
yes, my lord.
Read it very slowly. Read it very slowly.
Yes, my lord. Since the appeal against the judgment and order dated 10/1/2020 passed by the learned CGM Bongaigaon in NICR case number 34/2018, sentencing the accused appellant to undergo SI of 3 months, along with a compensation of 13,10,000 in default for 1 month for committing an offence under section 138 of the Negotiable Instrument Act. Seen the memo of appeal along with certified free copy of the judgment and order passed by the lower court. Learned counsel for the respondent is also present. Heard the learned counsel for the appellant. The case record reveals that appeal was filed in time. The ground mentioned in the memo of appeal are good grounds for appeal. Hence, the appeal is admitted for hearing. Appellant is directed to pay 20% of the fine amount awarded by the court below within 60 days from the date of admission of this appeal. Well, this is the order passed.
Now, please come to page number 56.
Hello?
The prayer of the appellant in his appeal under section 374(3).
Prayer of the
Kindly
appellant.
read.
In view of above facts and circumstances, it is therefore prayed that your honor would be pleased to admit the appeal, call for the record of NICR case number so and so from the court of the Chief Judicial Magistrate Bongaigaon, and upon hearing, be pleased to acquit the appellant by setting aside the judgment and order dated 10/1/2020, passed in the said case for the ends of justice. This is the prayer.
Then there is another part.
Then pending the disposal of the appeal, the appellant may be allowed to remain on previous bail. My lord.
Now, was there any prayer for suspension of the sentence passed by learned CJM? And they
My lord,
said
there is no such
No such
prayer has
prayer.
been prayer made.
the court, the learned appellate court also did not pass any order allowing him from this order, as you can peruse,
Yes, my lord.
that allowing him to remain in the previous bail.
Yes, my lord.
Appeal was admitted, is found that there are sufficient grounds.
No, appeal
But
may be
Did
admitted.
not stay the or suspend the sentence imposed upon the appellant
Hmm.
from this order, as you can
Yes,
see.
my lord.
And also you can see that there is no such order asking him or allowing him to remain in previous bail.
Yes, my lord. That is also very right. But my lord, the
So what
difficult,
will be the procedure if in terms of the order, the 20% of the amount as provided under section 148
yes, my lord.
compensation
Yes, my lord.
directed to be paid. Compensation amount means the amount which was to be paid,
Hmm.
amount that was the check, which was a check amount that has been found. So 20% of that amount
Hmm.
not paid.
Not paid, my lord.
Then since there it was not a conditional order for admitting the appeal,
Yes, my lord.
how your prayer?
No, my lord, there may not be any speaking order by the learned appellate court that the sentence was suspended or he shall remain on previous bail. But there is when there is a statutory mandate, my lord, it become obligatory on the part of the
There was
Eh?
no, that is why we are asking you, Mr. Decker, kindly show us that what else not paid compensation amount as directed by the appellate court under section 148, not
yes,
paid.
my lord.
What will happen? If there is any conditional admission of the appeal, that can be considered.
Yes, my lord.
If there is suspension of the sentence imposed upon the concerned appellant, that can be considered. But in this particular order, while admitting the appeal, nothing.
No, my lord may then kindly come to 148 of the negotiable
Yes, sure.
instrument.
Yes.
May I please, my lord?
Sure.
I may be allowed to read. 138. Notwithstanding anything contained in the Code of Criminal Procedure Code 1973, in an appeal by a drawer against the conviction under section 138, the appellate court may order the appellant to deposit such sum which shall be a minimum of 20% of fine or compensation awarded by the trial court. Now, my lord, the first thing which needs to be observed in this particular provision, that the very provision begins with a non-obstante clause. And thereafter, my lord, legislature has used the word may, because it is specifically stated that the appellate court may order the appellant to deposit such sum which thereafter, my lord, the legislature has used the word shall be a minimum of 20% of the amount. Now, my lord, when there is a non-obstante clause is being incorporated by the legislature, then it cannot be given a liberal interpretation. Now, my lord, though there is no possibility of giving a liberal interpretation, but my lord, if the learned appellate court want to exercise its discretion, that all right, in this particular case, there may not be any necessity to deposit 20% of the amount. In order to do so, the learned appellate court has to give a special reason for not
See, it is
imposing.
not a fact, Mr. Decker, that the appellate court, in exercise of the power under section 148, has directed.
Yes, my lord.
Now, your question is the non-compliance of that order,
Non-compliance of the
depositing
order.
of 20% of the amount.
Hmm.
You said that the appeal should be dismissed.
Yes, my lord.
Appeal is a statutory
appeal cannot be
that
dismissed,
be
my lord.
considered.
That I fairly admit.
Now, what remains? How will you get this 20%?
No, my lord, if there is an order passed by the appellate court to deposit 20% of the amount, and subsequently the appellant did not deposit before the learned appellate court, then entire provision of 138 of the negotiable instrument will become
This is
redundant. or become inoperative, my lord. So, my lord, the things has to be
138
interpreted and assessed.
138 is the finding of the magistrate because of the bouncing of the check amount. Was
Yes,
supposed
my
to be funded. Now that order which the appellant have challenged,
Yes, my lord.
there is no conditional or only thing direction is that you have to deposit 20% of the.
No, if there is no speaking direction, my lord, when there is a statutory direction in the statute itself, my lord,
That doesn't mean that
that
the.
has to be honored and that has to be
That
complied
is
with, my
why
lord.
the appeal
Ah.
cannot be dismissed, as you have said. What next? That is why I'm asking you.
No, my
If
lord,
that amount is not deposited,
yes, my
the appellate court has other provisions to take.
no, definitely there is other provision, my lord. That is why
Yeah.
I would like to draw the attention of this honorable court again to page 60.
Hmm.
That is the last part of the order dated 15/3/2020. I am reading again.
Hmm.
I have gone through the aforesaid judgment. The deposit of 20% of the check amount was not the condition precedent of vacating the order of suspension of stay. My
Your
lord has right.
application at page
No.
61.
Yes, my
Your
lord.
application was 61 and the prayer indicates that you want that dismissal of the appeal.
Yes, my lord.
That's what has been rejected. And
No,
the
that may be
statutory appeal
rejected.
cannot be rejected.
My lord, that may be rejected.
You can always approach the appellate court again
No,
for
I can,
appropriate direction of the appellate court.
my lord, I can approach the appellate court again. But the difficulty
Where
is
is
that
that difficulty? Because look
the
at prayer in
difficulty
page
is the
61.
difficulty is because of this part of the order.
Why?
Because, my
That is
lord,
what.
as
Last part, there is no provision to dismiss the appeal if the said amount is not paid within 60 days.
no,
Which one?
the first part of the last paragraph, my lord, I have gone through the aforesaid judgment. The deposit of 20% of the check amount was not the condition precedent for vacating the order of suspension of stay.
Where is the suspension of stay?
Now, where is this certificate? Because, my lord, if my lord will come to order dated 22/2020, there, my lord will found there is no specific speaking order passed.
22.
My lord may kindly come to page 58.
Huh.
Because this is the order by which the appeal of the appellant is being admitted. But in this particular order, the learned appellate court did not say anything about the
So-
suspension of stay.
Mr. Dekra, you are agree with that part of the order that the 20% check amount was not the condition precedent for vacating the order of suspension of
No,
stay.
I do not agree with this part, my lord. I am agreeing with the later part. Because only because somebody is not depositing 20% of
But
the amount,
what-
appeal cannot be
Listen,
dismissed.
The
To that
appellate,
extent, I agree, my lord.
the appellate court acted on your application.
Yes, my lord.
This order has been passed on the basis of your application.
No.
And on your application, you have made it clear that appeal should be dismissed.
Yes, my lord.
So he
Yes.
has considered appeal cannot be
Well,
dismissed.
There may be slight error or irregularity in the
You file
petition which I
appropriate
have filed.
application
My
for
lord.
necessary compliance, for a necessary direction of the appellate court to comply the payment of 20% by the appellant.
My lord, this is the direction that I need from this
File
one.
appropriate application before the appellate court.
No, my
Your
lord,
application is different. Prayer is different. Accordingly, that prayer has been rejected.
all right, my lord. Then
Then
my lord may direct me to,
up to you. Why should you direct you?
no, my lord, there has to be a speaking order.
That is
Because-
that is the reason. Look at your prayer and how the learned appellate court has acted upon. Rightly acted upon.
No, it is
Appeal
not
can-
rightly acted upon,
Why?
my lord, because of the first part of the order.
Are you agree with the first part or the second part?
No, my lord, I am not agreeing with the first part. I am agreeing with the second part. If somebody do not pay the 20% compensation amount before the appellate court, because of that reason, appeal cannot be dismissed. But, my lord, if there is any suspension of stay, the order passed by the appellate court, that can
Where
be
is-
interfered with.
Where is that suspension of stay?
So, there may not be any suspension of stay in the order dated, my lord,
28 October.
22/2020, but in order dated 15/3/2022, by speaking order, the learned appellate court has observed that I have gone through the aforesaid judgment. The deposit of 20% of the check amount was not a condition precedent of vacating this order of suspension of stay. Now, my difficulty with this part, my lord, not the later part. And that is why I approached before this honorable court.
Okay.
In support of my submission, my lord, I would like to place two judgments.
Yes, yes, please.
Thank you.
Because judgment detail.
My lord, the first judgment that I would like to rely of the Punjab and Haryana court. Now, my lord, this judgment, the learned court has referred to Surendra Diswal case, and I shall come to that particular judgment later. Now, my lord, may kindly come to para 9, my lord. Para 9. Now, so far as the submission on behalf of the appellant, that even considering the language used in 138 of the Negotiable Instrument Act as amended, the appellate court may order the appellant to deposit such sum which shall be a minimum of 20% of the fine or compensation awarded by the trial court. And the word used is not shall, and therefore the discretion is vested with the first appellate court to direct the appellant accused to deposit such sum, and the appellate court has constituted it as mandatory, which according to the learned senior advocate or the appellant would be contrary to the provision of 138 of the Negotiable Instrument Act as amended is concerned. Considering the amended section 148 of the Negotiable Instrument Act as a whole to be read with the statement of object and reason of the amended section 148 of the Negotiable Instrument Act. Though it is true that in amended section 148 of the Negotiable Instrument Act, the word used is may is generally to be construed as a rule or shall. Well, this is important. And not to direct to deposit by the appellate court is an exception for a special reason are to be assigned. Therefore, amended section 148 of the Negotiable Instrument Act confer power upon the appellate court to pass an order pending appeal to direct the appellant accused to deposit the sum which shall not be less than 20% of the fine or compensation either on an application filed by the original complainant or even on an application filed by the appellant accused under section 389 of the CRPC to suspend the sentence. The aforesaid is required to be constituted considering the fact that as per the amended provision of 138 of the Negotiable Instrument Act, a minimum of 20% of the fine or compensation awarded by the trial court is directed to be deposited, and that such amount is to be deposited within a period of 60 days as may be directed by the appellate court for the sufficient cost shown by the appellant. Therefore, if amended section 148 of the Negotiable Instrument Act is purposively interpreted in such manner, it would serve the object and reason of not only the amendment in section 148 of the Negotiable Instrument Act, but also section 138 of the Negotiable Instrument Act. Negotiable Instrument Act has been amended from time to time so as to provide inter alia speedy disposal of the case relating to the offense of the dishonor of the check, so as to see that due to the delay tactics by the unscrupulous drawer of the check, dishonored check, due to easy filing of appeal and obtained stay in the proceeding, an injustice was caused to the pay of the dishonored check, who has to spend considerable time and resources in the court proceeding to realize the value of the check, and having observed that such delay has compromised the sanctity of the check transactions, the Parliament has thought it fit to deem section 148 of the Negotiable Instrument Act. Therefore, such purposive interpretation would be furtherance of the object and reason of the amendment in section 148 of the Negotiable Instrument Act and also section 138 of the Instrument Act. My lord, the similar situation has also been dealt by the Honorable Apex Court, and that narration my lord will find at para 11 and 12.
Yes, we have seen that.
Yes, my lord. So it has been clearly been held, if somebody, in spite of there is a direction of the appellate court, did not deposit the 20% of the check amount, then the stay cannot be suspended. The judgment passed by the trial court cannot be suspended, my lord. This has to be a condition precedent before admitting the appeal. My lord, at para 16.
Hmm.
The learned High Court has also referred to a judgment passed by the Honorable Apex Court. And based on that, it has been held that it is mandatory before admitting the appeal, whatever percentage of amount that has been fixed by the learned appellate court, that has to be deposited first before the appellate court go into the merit of the appeal. Now, my lord may kindly come to the second judgment.
Just a minute.
Deeply obliged.
Second judgment has been cited by the Punjab and Haryana.
Yes, my lord. But for the satisfaction of the court, I have furnished the copy of the judgment.
You preferred revision petition? You have preferred a revision petition.
Petitioner file, respondent, my lord, respondent file the appeal, my lord. Appeal is admitted. My
You have preferred a revision petition. Are you aware?
lord. No, my lord.
Not aware.
No.
Mr. Decker,
My lord,
record reveals that the appellant preferred a revision petition.
but a revision is not maintainable, my lord, before the first appellate court.
Revision petition before this High Court.
No, my lord, that I am not aware, my lord. No copy has been served on me till date.
No, it is
Record reveals. What order was passed on 15/3/2022? Your order was
I am
rejected.
only aware of the criminal appeal number 5 of 2020,
Mm.
but I am not aware, my lord, if any revision petition is being prepared.
You wrongly mentioned. Anyway. Yes, Mr. Ahmed.
Milord.
What is your submission? Tell us.
In the page 60, my lord, the trial court rightly passed the order, my lord.
Very good. Yes.
And I have no knowledge any revision petition file is not, lord.
No, here the order sheet reveals the revision petition of this revision.
Yes. Yeah, against the appeal order, my lord. I have no knowledge, my lord. And that part revealed from the record, my lord.
My lord, my case is otherwise very simple. When there is a statutory mandate,
Just tell us one thing. The learned magistrate allowed you to remain on previous stay as per the record. You filed a petition before the learned magistrate to allow you to remain on previous stay because you said that you will prepare an appeal. And learned magistrate passed that order on 10th of January 2020, extending your previous bail up to 11th of February 2020. Can you tell us what happened thereafter?
And thereafter, I have no knowledge, my lord.
The records of the learned appellate court before us doesn't indicate that you have filed any application for the appellate court to bring suspension of the sentence or allowing you to remain in previous. There is also no such order in this particular set. Then there is no also application from your side while filing the appeal before the learned session judge. Record.
I cannot go beyond the record, madam.
We'll pass the order today itself. Yes, any other party here?
No, madam, there is
Okay.
only.
Yes, Mr. Teka, we'll take care of. Be Teka. For dependent. A.M. Ahmed for the response number 1 and Mr. P. Sharma. Additional participant. We'll pass the order.
Deeply obliged, my lord.
Obliged.
Yes.
May I please,
Yes, ma'am.
Lordship, on the last occasion, the honorable court had asked if we want to go for mediation. We are ready to go for mediation, Your Lordship.
Lordship, this after this interim order, I'm only receiving 1,500 per month. That is, I'm in financial constraint.
Lordship, at this point, Your Lordship, the respondent number 2 has herself submitted in the trial court below that she has the experience of 10 years and she is working in two beauty parlor, Your Lordship. One she owns and in one she gives her services. So,
This on the last occasion also clarified.
yes, Your Lordship.
No one
And
fighting, right?
Lordship, these are the facts of the case which are not disputed by either of the
Order
parties,
has
Your
leaders
Lordship.
counsel appearing for the petition. And Mr. R.K. Malakar, learned counsel for the response number 2. Also heard Mr. M.S. and learned additional public prosecutor. For the state respondent number. The response number 2. is the legally married wife of petitioner. On 17/5/2017. The response number 2. Legally married wife petitioner, and they were married on 13/03/2014 according to the Hindu calendar. On 17/5/2017. The response number 2. Filed a petition under section 125 CRPC. Along with section 7 of the Family Court Act 1984. Before the learned principal Judge Family Court, Kamrup, Guwahati. Praying for payment of maintenance allowance to her payable by the present petition. After hearing the parties, petition of for maintenance of rupees 12,000 per month, including medical costs. With effect from filing of the divorce case by the petitioner by case number FC within the civil 418 of the 2017, and another amount for maintaining the court case is paying rupees 3,000 per month. After hearing the parties, I, the respondent number 2 and the present petitioner, the learned principal Judge Kamili Court, in FC within the criminal case number 2. The judgment dated 19/09/2022. Directed the present petitioner to pay an amount of rupees 6,000 per month to the respondent number 2 as maintenance allowance from the date of the said order dated 19/09/2022. Within the first week of succeeding month, it is to be noted herein that by an order dated 26/02/2018, passed by the learned principal Judge Family Court in said FC criminal trial, referred by the directed the petitioner to pay interim maintenance at the rate of rupees 3,000 with effect from 26/02/2018, and the respondent number 2 received the said amount of rupees 3,000 per month regularly from the petitioner till the passing of the said judgment dated 19/09/2022. Agree with the judgment dated 19/09/2022, passed by the learned family principal Judge Family Court. The petitioner preferred this revision petition on 02/11/2022. And the court on 07/11/2022. Issued notice. To platform. Letter by order dated 29/11/2022. While directing the petitioner to take first steps of the respondent number 2, I represent respondent number 2 here, comma, wife of the petitioner. Also directed to pay rupees 1,500 as monthly maintenance to her, that is respondent number 2, until further orders. And state the operation of the impugned judgment in order dated 19/09/2022, passed by learned principal judge NFC criminal case, which is still you are receiving 1,500.
Yes, Lord.
Mr. Malakal and counsel appearing for the
Be thus, Lord.
either. Appearing for the respondent number 2 submitted on instructions of the respondent number 2 is receiving with 1,500 per month as maintenance. It's regularly in terms of the order dated 29/11. According to the respondent number 2, the very meager amount to manage her. Considering entire aspect of it, and as agreed by the matter is referred to the Guwahati High Court Mediation Committee. Both the petition and the respondent number 2 shall appear for mediation before the consultants committee on eight zero 8/2020 at 10:30. As this order has been passed in presence of the counsel for the petitioner as well as Councillor MS Peters, and counsel for the respondent number 2, Mr. Peter. No formal notice need to be issued to the petitioner as well as the respondent number 2 for their appearance before the mediation center in the Guwahati High Court. The list on 3rd of October.
No,
Third,
Lordship, not on 3rd, your Lordship. May not be on third, your lordship.
Court of Appeal.
Court.
The Guwahati High Court shall submit it. Honor 30. 09.
Deeply obliged.
May I please your lordship? Lordship, in this matter, my lord, petitioner has taken back the brief from us, my lord, on 5/8/2024. So my respectful submission, my lord, our name may be withdrawn from this case, my lord.
Where is that copy that it has been?
That
Mr. SAB Kabil and counsel appearing for the petitioner Asraful Islam. Arda. Yes, Kapoor. Production. Yeah, Mr. Kapoor.
M. Rahman.
Emra. Mr. Kabil and counsel for the petitioner submit that on 05/08/2024 said petitioner took at the brief from them to engage new set of in that regard. Mr. Kabir has placed Mr. Kabir on account. No applicant certificate. It is 05/08/2024. Issued by one of the counsel for the petitioner such as with the signature of petitioner regarding taking of records of it. In view of the latest matter again on 21st of make it 20, don't make it 30th. Do you have a copy?
yes, my lord.
Copy of invoice read by me.
Deeply obliged.
7 and 8, Lordship, I am for the private respondent, your Lordship.
Mr. Som,
Lordship,
come at 2 o'clock. You come at 2 o'clock, we'll pass the order.
2 o'clock. Lord. Oblige, your Lord.
Both the petition as well as the sole respondent remain unrepresented by the method of second appearance. So, the name of three councils have been retracted for the petition and a council for the respondent. List of 4 each. Yes.
My lord, the section 294 that has been registered in this case here, okay, does not attract the main ingredient. The affair does not attract the main ingredients of the 294 of IPC. My lord. So, the main ingredient for 294 has to be any obscene act or word that has been spoken or done in a public place. But in the instant case, Your Lordship, the public place is nowhere involved. They have in their
Whether search sheet has been filed,
no till date.
right? After completion of the investigation, if the investigating officer finds that it is required to alter the section, may approach the SCGM, right?
Yes.
May alter the section as per the approval of the SCGM. Why it is-
Because the affair that
We have seen the act.
Yes.
We have
Yes.
seen the act.
294 does not
Initially, the case has been registered under section
294.
Investigation is not yet complete. If during investigation, if the concerned investigating officer finds that the section needs to be altered or changed, right?
Yes.
So it may approach the concerned magistrate, may change it, may be allowed or may not be allowed by the magistrate. Thereof, investigation in the nascent stage.
But yes, I would like to rely upon some certain judgment.
Kindly tell us the judgment which you are relying on, what are the facts of it, and at what stage the concerned accused approach the court.
In the judgment passed by the Kerala High Court, the
What are the facts of it?
that they have used certain obscene words in the informant has alleged that the accused have used obscene words, but in the said affair, the informant has not categorically mentioned the obscene words that has been used against him. So in that regard, the Kerala High Court has
At what stage? At what stage the Honorable Kerala High Court has passed that order which you want to cite? After filing of the charge sheet, or at the time of framing of charge, or after framing of charge, or taking cognizance, what?
In this case, even charge sheet has not been filed.
At what stage? This is a 482 petition, right?
Yes.
So tell us. Why do you have to interfere here? Why should you interfere? Investigation not yet complete. Only the statements have been recorded. Your statement has also been recorded.
Yes. Hello.
You applied for net,
net exam.
which particular clause in the net application shows that regarding police case pending or not is required? Clause the net application.
Well, I have not.
We have seen net application because we know
Yes.
many family members of us appears in this exam.
But upon selection, your lordship,
Upon selection will nothing happen. If it is an advertisement to a particular post, there you may require whether there is any police case pending against you or you have been made an accused or you have been punished.
Yes.
How it is related to filing a net application.
actually,
You are not applying for any post on being selected in net.
no. Upon verification, your
There is no such clause in the net application, to my knowledge. That is why we are asking you to us. It is available in the net. As soon as you open in the net, you will get it.
Yes.
Are you sure?
Yes.
That that clause is there?
no. Upon the net application, there is no.
It is not there. Only when you will apply to a post on being selected in a
On
net
being
exam.
selected,
In that particular post, that there may be some clause.
Yeah.
Or for police verification or something. That is
background
another case.
verification.
Any other ground?
Actually, ground was that since the FIR does not contains the main ingredients of 294.
At this moment, the investigation is not complete.
This was my ground, Your Honor. This was my ground, Your Lordship.
We have seen that.
Yeah.
Investigation not yet complete. That's why we said the investigation in essence still.
Yeah.
Possible. There is a judgment of this court. His Lordship Justice Ansari has passed the judgment. If you have read his ALT or the LR very well, you know.
On to the
406, 407, 420, all were included by police. The Lordship have discussed in that 406 ingredients of 406, 407, how come add together? They cannot stand. Those sections of their own which all together cannot stand. There, dear Lordship have discussed. You should read, young advocate, if you do not read the judgment, what will happen? Yes.
I'll go through it.
What do you have to say? You are appearing for the respondent number 2.
Respondent number 2, yeah.
Please submit. Yes.
Para number 5 of our affidavit in opposition. Para number 5 of our opposite in affidavit in opposition.
Yes.
That with regard to the statements made by para so of the application, the deponent admits the contents of the FIR dated so. The same has been registered and numbered as Lattersil PS case number under section 294 of the IPC. In the said FIR, it has been stated that the petitioner Anusha Kalita was an employee in Abid Siksa and that a leave as requested by her could not be granted to her subsequent to which she used abusive language being to the proprietor of Abid Siksa and also resigned to WhatsApp message without service of any notice period nor handing over any official belongings. It has also been stated in the FIR with a view to bring the reputation of the organization down by continuously reviewing in Google by herself and in her and her fellow mates, which brought the reputation of the organization down publicly and which in turn has affected the organization's business. It has also been stated in the FIR that it is a continuous mental harassment for personnel from business perspective. So the only reason why the complaint was filed, Your Honor, was because she has tried to bring down the reputation of the organization by continuously putting her 1-star rating. She herself has done in to other colleagues or whoever her acquaintances.
How do you know?
Your Honor,
How do you know that
One-
he has influenced others? How
in
do
the
you
same para, Your Honor, it has also been stated in the said FIR that one Pranita Bhuya who was employed with Abid Siksa left the organization 30th September without tendering resignation, also reviewed by giving 1 star under the influence of the petitioner. Which fact has
How do you
been
know? That's
Which
the
fact has been
the
admitted by
present
Pranita Bhuya?
petitioner as influencer.
Because none of the persons who have given that 1-star rating are connected to the organization.
Hmm.
It is only after this incident, the very day, she had done this. And soon after the complaint was filed, this thing has stopped.
How do you know that the petitioner has induced those persons to give you 1-star?
So one Pranita Bhuya
Hmm.
was an earlier employee.
Hmm.
She has also done that, and she had telephonically admitted to doing that at the influence of her.
The
One
CDR
of
report
them.
doesn't say anything.
You know?
The CDR report
Yeah.
obtained by police doesn't show anything that there was any call between the informant and the concerned person whom we are talking about in the affair.
I can comment anything on that, but that has been informed to me by the respondent number 2.
In the CDR report, there is nothing.
Okay.
In the CDR report, there are 2 calls from the petitioner, but there is no such call
To
from the
Pranita
concerned
Bhuya.
person.
Because
Entire CDR report is in the case record.
I'm not aware of that. This fact has been
Anything
intimated by
else?
the respondent number 2.
Anything else?
No, nothing else, Your Honor. The
Yes,
fact is,
Mr.
the fact is, there should be nothing that should be done by them to bring down the reputation of the organization. That is our purpose. We also do not want to block the career of any person. However, bringing down the reputation of an organization is also not right.
Okay. Yes.
Lordship, investigation is going on, Lordship. The initial stage and a statement of the husband and Lordship is there, Lordship. And his
In the affair, is there any statement from the affair? Can you show us anything that it was in a public place, that incident of? You read 294. You read 294 FPC and tell us whether the incident occurred in a public place.
as per the statement, their statement
From the affair we are talking.
from the FIR. Organization down, repetition of the down by continuously reviewing in Google by herself and her fellow men. This is for the repetition of the organization of public which has affected the company's business. This is content manifest. And from business perspective, those who have contributed report 1 star after yesterday evening incident in link with in Lordship in the FIR, it is mentioned about reviewing in Google by herself and her fellow men.
How it is related?
But Lordship, CDR, there is nothing.
Heard Mr. R.D. Goswami, counsel referring for the petitioner. Ahmed Sandas, Garner Additional Public Prosecutor. Referring for district respondent above. Also heard Mr. A.S.I.K. You are Mr. Iseke, right?
Yes.
And counsel for the respondent number 2 informant. The respondent number 2, listen. The petitioner has filed this criminal petition on 02/02/2024, praying amongst others to set aside and quash the FIR relating to Lotus Hill Police Station case number 190/2023 dated 18/10/2023, registered under section 294 IPC against her, corresponding to GR number 7780/23. On the basis of an written FIR lodged by the respondent number 2 on 18/10/2023. The respondent number 2 on 18/10/2023 lodged and written FIR before the officer in charge of police, Lotus Hill Police Station, stating that the petitioner, an employee of her organization, sought for a leave on 17/10/2023 that could not be granted to her, for which the petitioner used abusive language to her senior ID informant and resigned through WhatsApp message without serving any notice period, and also did not hand over the official belonging. In the said FIR, the informant respondent number 2 further alleged that since then the accused petitioner was trying to bring the reputation of her organization down by continuously reviewing in Google by herself and by her fellow men, for which her organization earned a bad reputation in the eyes of the public and thereby affected the business of her organization. The said act gave her mental harassment both personally and from the side of, and both personally and also from business perspective. It is stated in the FIR by the informant that after the said incident of 17/10/2023, on continuous putting up one stud by the persons concerned are not connected to the organization, connected to her organization, and never been linked with the said organization. Stating that one Porinita Bhuya was her employee, left the job on 30/09/2023 without issuing any resignation and reviewed her organization on 18/10/2023 under the influence of the accused petitioner, and that said Parinita admitted over phone in the evening on 18/10/2023 that she has done it under the influence of the accused petitioner. And the said incident created by the accused petitioner just for a day leave affected her personal and professional reputation. Though in the said affair, dated 18/10/2023, the informant respondent number 2 gave a list of 16 such reviewers and requested the concerned officer of the Lotus Hill Police Station take immediate action as the reputation of her company was at stake, and the Google rating of her company was going down rapidly. So the FIR was accordingly registered as Lotus Hill PS case number 190/295. By order dated 06/02/2024, the court, while issuing notice to the respondents, called for the scanned copy of the records of said Lotus Hill PS case number. Mr. Goswami, Land Counsel appearing for the petitioner, submitted that though the FIR dated 18/10/2023 of the respondent number 2 has been registered as Lotus Hill PS case number under section 292 against the petitioner, but from the mere reading of the FIR, it can be seen that there is no such ingredients of the offense under section 294. It is also submitted by Mr. Goswami that the petitioner appeared in the national eligibility test and if in the basis of said FIR of the respondent number 2, the 18/10/2023 of the above is allowed to correspondingly raise the case. Is allowed to proceed. Civil case for the regency book. Mr. Goswami comment that the proceeding will be safe. What was and the FIR. Mr. Saikal and counsel appearing for the respondent number 2. From the affidavit of the respondent number 2 filed on 23/04/2024 in the property. Place that the petitioner misbehaved with the respondent number 2 and involved herself with others lowering the name of her organization thereby name and reputation by rating down of her organization in the Google. Ms. Das, Learned Additional Public Prosecutor, submitted that the police have already recorded the statement of the petitioner, sorry, the informant, and other witnesses will acquainted with the facts of the case, relating to say Lokasil case number 30, and also that of the petitioner. And investigation of the said suspect. From the records of the Lotus LPS case number 30, placed before the court by discussed, it can be seen that the investigation in Lotus LPS case number 30 is international stage. The CTR reports of the mobile number of the petitioner also reflects that the petitioner on 17 10 2023 made two calls to the restaurant number 2 in Oman at 20:59:19 hours and 20:59:52 hours, where the first call was for 7 seconds and the second call was for 6. And C call, and as per the same city, yeah, but it is also seen from the records of Judge Russell Pierce case number that police have recorded the statement of petitioner. Further, police, after completion of the investigation, police during investigation seized the mobile phone of the respondent number 2 and then recorded the statement of the section 41A. On completion of the investigation, the concerned investigating officer Russell Pierce on 28/11/2023 submitted the charge sheet by number 5CS 134 against the petitioner under section 295. Yes, Ms. Das.
Lordship.
Read the last pair till the next. Read the next.
During the course of investigation, sufficient evidence are found against the said accused person of committing offense under section 294 IPC. As on 17/10/23, 8:59 p.m., the said accused called the informant mobile number so-and-so from her mobile number so-and-so, abused the informant by using vulgar language, and at that particular point of time, the mobile phone on which the informant received the call was on loudspeaker, as a result of which the husband of the informant heard the entire conversation. A CDR of the informant's mobile number has also corroborated the fact that 17/10/23 at 8:59 p.m. the informant received call from the mobile phone of accused Anusha Kodita. Thus, prima facie is a case made out under section 294 IPC against the accused Srimati Anusha Kalita, and accordingly I submit the charge sheet against the said accused under the aforesaid section of law as fair trial. The witness mentioned in para 11 above will prove the fact of the case at the time of trial, and they may be summoned by honorable court.
You have read? Now read section 290.
Section
290.
290.
Read for us.
Section 294, obscene acts and songs. Whoever to the annoyance of others does any obscene act in any public place or sign, recite, or utter any obscene song, ballad, or words in or near any public place shall be punished with imprisonment of either description for a term which may extend to 3 months, or with fine, or with both.
Now read the affair of the
With due respect, this is to inform you that Anusha Kolita was an employee in Avid Shiksha. Yesterday, a leave could not be granted to her. She used abusive language to a senior senior owner Rinki Bordoloi, proprietor of Avid Shiksha, and resigned through WhatsApp message without serving any notice prior, nor handing over any official belongings. From there and then onwards, she is trying to bring the reputation of the organization down by the continuously reviewing in Google by herself and her fellow mates. This has brought the reputation of the organization down publicly, which has affected the company's business. This is a continuous mental harassment, both personally and from business perspective. Those who have continuously put 1 star after yesterday's evening incident is no way connected to the organization and never being linked with Avis Shiksha. Also, this is to be mentioned that Parinita Bhuya, who was employed under us and left on 30th September 2023 without any resignation, reviewed us today under the influence of Anusha Kalita, as Parinita admitted of her phone this evening. This is to inform that all the dues of these employees were clear till the month of September 2023.
Where is the public place mentioned in the FIR? In the FIR, where is the place mentioned? Any place mentioned? Forget the public. Even if you read 10 times,
Mm.
you'll not get the word public place or the call place. Only place is Google. Now, whether the Google floor is called considered, can be considered as a public place.
It is a public forum.
So what's the definition of public?
Your Lordship, in this regard, can I
Public includes any class of public and community. Space, public servant. Space, to any public or any community. Public place.
Yes, tell us, ma'am.
My license.
Yes, you want to say something?
Lordship,
My lordship, can I place the judgment regarding the public place? It was passed by the Honorable Bombay High Court, wherein the Honorable High Court has stated in the paragraph 12 of the judgment, the main ingredients of section 294 of the IPC is commission of an obscene act at a public place. The Black Law Dictionary 8th edition defines public place as public place, any location that the local, state, or national government maintains for the use of the public, such as highway, park, or public building. Next paragraph, paragraph 13. Section 294 of IPC is meant for punishing person indulging in obscene act in any public place causing annoyance to others. As such, the places where such obscene act is committed needs to be a public place and meant for use of public at large. Public must have free access to such place so as to call it a public place. The place where public have no right, rather a lawful right to enter into, cannot be said to be a public place for invoking the penal provision of section 294 of IPC for calling a place as a public place. It must be shown that the public at large has a right to have free ingress to such place.
So,
Your Lordship, in the instant case, Your Lordship, the respondent number 2 has alleged the accused have used of misbehave with her over telephone, and telephone is not a public place, Your Lordship. Telephone, mobile phone cannot be considered as a public place.
public place intended for use by or accessible to the public and includes any public convenience.
which judgment? That is why we're asking you whether the Google platform is a public place.
No, it cannot be considered.
We complete the judgment today.
Lordship.
Is there any mention in the FIR regarding the public?
No, Lord.
Right.
Your Lordship, can I submit the
With the lordship.
You have to give one letter.
Lordship, this matter was called on earlier occasion. I just left for a moment, Lordship. Now, I believe my learned friend
No, we
was
said
here.
we'll take it up at 2 o'clock. That's the thing.
Lordship.
Okay, we'll have it at 2 o'clock.
My pleasure, Lordship. My matter relates to my lord, the proceeding sanction, my lord, without taking proceeding sanction, my lord, recognizance was taken, my lord. And when this, we came to know, my lord, we filed a petition before learned CGM Sonitpur, my lord, and our petition was rejected, my lord. What are army personnel, on duty on particular date? Here we filed a petition, page 34.
Mr. Medhi, just a minute.
Yes, madam.
We amended the cost title.
Yes, my lord.
When,
It is there, my lord.
on which date you have amended the cost?
My lord.
When you have amended the cost title? When?
I forgot, my lord, but it is, we are amended, my lord. Initially, my lord, this, the cognizance was taken that that order was not in the cost title, my lord. Subsequently, my lord, we inserted, my lord, in page 1 itself, my lord. The impugn order dated 21/12/2023 Annexure I and impugn order dated 23/11/2020. This was not in cost title, my lord. Immediately after court order, my lord.
Yes. Mr. Sharma.
My lord.
Cognizance of the offences under section 323, 354, 506 IPC taken against the petitioner by the learned CJM Sanipur. If possible. Read the provisions of those sections.
Well, actually, my lord, petitions is not available with me, my lord. Kindly, I will go to my lord elsewhere.
Ninety-seven, two. Nine hundred,
Mhm.
600.
Yes, my lord, section 197, my lord, subsection 2, my lord.
Hmm.
It is clear, my lord.
Yes, kindly read. That is the
Yes,
reason
my
we are
lord.
asking you.
Yes, my lord, no court shall take cognizance of any offence alleged to have been committed by any member of the armed forces of the Union while acting or purporting to act in the discharge of his official duty except with the previous sanction of the central government.
So there has to be discharge of official duty.
Official duty.
Now look at the FIR.
FIR is my lord,
Page 18.
page, yes, page
Read
15,
page 18.
18. 18 is my lord subsequent. First one is 15, my lord. There's two FIR files now. One is filed with the lady, my lord, that was my lord, registered and certificate was filed under which of that, my lord. And here on the same day, 18 also file, my lord.
Yes,
Okay,
my lord.
read
Dated,
page
my lord,
15.
31/20.
Read page 15.
Yes, my lord. With due respect, I beg to state that the person named below on 31/2022 at about 1 AM had attempted to block the village road situated near our house. And as and when we rushed to the spot, the army personnel of the Mishamari Army Cantonment, by pushing me behind by backside, outrages my modesty, and as I resist, they had hurt my back right side with blunt weapon with an attempt to kill me. That when I asked them why they are outraging my modesty and attempted to kill me, they replied that they had order from Brigadier P.B. something that is so and so, my lord, Commandant Mishamari. The residents were saying not to block the road with iron fencing. I was treated for the injury sustained on my right back side, that the photograph enclosed here with shall prove the identity of the said person. This is first one. Then
18.
Then my lord 17. 17 by some General Secretary, Mishamari Somaj Kolyan Committee.
Yes, my
Mm. Yet another.
It appears that they were in duties
My lord.
and they have obstructed the road.
Yeah.
And it was used by the people there,
Right.
and they are aggrieved by obstruction of the road,
Right.
right? By
Right.
this army person,
Right.
and that happens to be the uh, the road going to the cantonment,
Right.
right?
My lord.
And people are using that road.
No, my lord, that is, my lord, the sketch map is there, my lord. Here, my sketch map also made a call, my lord. Here,
Where, which page?
yeah, sketch
My
map
lord,
is
in
there.
the my lord,
Record
scan
is
copy, my
record.
lord.
Record
This
is
is
called-
the
Scan copy record, my lord.
yes, my lord. This
Okay, we'll
is
come
my
back
lord.
at you.
My lord.
So from the record, you just see whether previous sanctions were obtained or
No, no,
My lord.
and also you are aware if the previous sanctions are not taken, that doesn't mean that the proceeding will lapse. What is the next stage? Tell us at all.
My lord.
it is open to get sanction, my lord, subsequently also, my lord, but without.
There is a judgment, Honorable Apex Court. Honorable Justice Gogoi dealt with the matter, enter where the sanction is required, where sanction is not required. Right? Read the judgment, full judgment, SCC is there. Record is it available?
My lord. Record, my lord, there is none. But my lord, the order is my lord.
You,
21/11/2023.
is a page 42, my lord.
Taking cognizance.
Yes, my lord.
Yes.
My lord, 460, my lord.
468, my irregularity, my lord. Irregularities which are not doing vacated proceeding, it is 460E, my lord, taking cognizance of offense, clause A or clause B of subsection 190, my lord. It is different, my lord.
190 is cognizance of the offense by the magistrate, my lord. This is irregularity. Here, my case is, my lord, without prosecution, it is there is an Armed Forces Special Act, my lord, is section 6 and under section 197 2 CRPC, my lord. Without prosecution, the court cannot proceed, my lord. And in search sheet itself says, my lord, there is reflected section 45. Why they not arrested, my lord? Even this search sheet was filed, my lord. Because of this, for arresting the army personnel, the sanction of the my lord, the central government is required, my lord. Section 45, my lord.
Mr. Sharma,
My lord.
before reading the first FIR, let us also read the second FIR first.
Yes, my lord.
You read the page 18 slowly.
Yes. 18. Page 18, my lord. In vernacular, my lord.
Yes, that's more important.
Yes, my lord. সন্মানপূৰ্বক বিনীত নিবেদন এই যে মিছামাৰী মৌজাৰ অন্তৰ্গত পাতিদৈ ভেবেলা গংগানগৰ গাঁওখন মিছামাৰী সেনা বাহিনী ছাউনীৰ কাষৱৰ্তী অঞ্চল হয়। বিগত বহু বছৰ ধৰি সেনা বাহিনীৰ লোকে মিছামাৰী অঞ্চলৰ বিভিন্ন ৰাজহুৱা পথবোৰ অনাহকতে সুৰক্ষাৰ দোহাই দি বন্ধ কৰি দিয়াৰ যোজা কৰি আহিছে। উক্ত বিষয় সন্দৰ্ভত কিছুদিন পূৰ্বে ইংৰাজী 27/1/2020 তাৰিখে মিছামাৰী সমাজ কল্যাণ সমিতিৰ উদ্যোগত এখনি প্ৰতিবাদী কাৰ্যসূচী হৈ গৈছে আৰু উক্ত প্ৰতিবাদী কাৰ্যসূচীত উপস্থিত হোৱা জিলা প্ৰশাসনৰ প্ৰতিনিধি মাননীয় হিৰুমণি মিলি মহোদয়ে পথ বন্ধ কৰা বিষয়টি আলোচনাৰ মাধ্যমেৰে জিলা প্ৰশাসনৰ দ্বাৰা মীমাংসা কৰা হ'ব বুলি উক্ত দিনা উপস্থিত ৰাইজক আশ্বাস দিছিল। কিন্তু যোৱাকালি ৰাতি প্ৰায় এটা বজাত পাতিদৈ ভেবেলাৰ পৰা সেনা ছাউনী হৈ ৰেলৱে ষ্টেচনলৈ বা পুৰণা মিছামাৰী হৈ অন্য চুবুৰীয়া অঞ্চললৈ যোৱা পথটি সেনা লোকে হঠাতে ৰহস্যজনকভাৱে লোহাৰ ফেন্সিঙেৰে বন্ধ কৰি ওচৰত JCBৰে গাঁত খান্দি থকা দেখা পোৱাত পাতিদৈ ভেবেলা স্থানীয় মহিলাসকলে তালৈ গুচি যায় আৰু বিষয়টিৰ কোনো সিদ্ধান্ত নোহোৱাকৈ কি কাৰণত আৰু কিয় পথ বন্ধ কৰিছে বুলি সোধা পোছা কৰে। কিন্তু স্থানীয় মহিলাসকলে অতি বিনয়ীভাৱে সোধা পোছা কৰাত তেওঁলোকে উত্তৰ দিয়াৰ পৰিৱৰ্তে পাতিদৈ ভেবেলা স্থানীয় মহিলাসকলক আৰু উপস্থিত স্থানীয় ৰাইজক লাঠিৰে মাৰপিট কৰাৰ লগতে ঠেলা হেঁচা কৰি মহিলাসকলৰ মৰ্যাদা হানি কৰিছে। উক্ত পথ বন্ধ কৰা কাৰ্য কৰি থকা সেনা জোৱানৰ পৰা উপস্থিত ৰাইজে জানিব পাৰে যে স্থানীয় ৰাইজে দীৰ্ঘদিন ধৰি সুচল যাতায়াতৰ বাবে ব্যৱহাৰ কৰি অহা পথটি বৰ্তমান সেনা ছাউনীৰ মুৰব্বীৰ পদত থকা ব্ৰিগেডিয়াৰ নিৰ্দেশ মতে
বন্ধ কৰি দিয়া হৈছে। গতিকে মহোদয়, মিছামাৰী সমাজ কল্যাণ সমিতিৰ তদন্ত হৈ বিষয়টো সন্দৰ্ভত এখনি গোচৰ ৰুজু কৰি আইনী ব্যৱস্থা মেলাত ঠেলা হেঁচা and in the
Charge
charge sheet also, my lord, I read charge sheet, my lord.
Then we'll just see the language in the other FIR.
My lord, my lord. 15. And 15 is dated, my lord, 31. And
Same.
18 is dated 31. Yes, 31.
Can we read?
My lord, 15, my lord. First one. With due respect, I beg to state that the person named below on 31/2022 at about 10
10, not 10, 1 a.m.
One, my lord, sorry, my lord. One.
Midnight.
Yes, 1 minute in the midnight, had attempted to block the village road situated near our house. And as and when we rushed to the spot, the army personnel of the Misamari Army Cantonment, by pushing me behind by backside, outrages my modesty, and as I resisted, they had hurt my backside, back right side with blunt weapon with an attempt to kill me. Then when I asked them why they are outraging my modesty and attempted to kill me, they replied that they had orders from Brigadier Misamari. The residents are saying not to block the road with iron fencing. I was treated for the injuries sustained on my right backside. That the photograph encloses here shall prove the identity of the said person. In that, my lord,
Name of
second
the
FIR,
persons,
my lord,
name of the person.
name of the person, my lord. Army person, Brigadier.
Under the command of the brigadier.
Yes, my lord, Brigadier. Name of the person, the army personnel of Misamari Army Cantonment under the command of Brigadier P.B. Srishan. The name, my lord, specifically not mentioned.
First of all, the incident occurred at 1 a.m.
My lord.
in the night.
Hmm.
Matter relates to security of this particular Misamari canton.
My lord.
The armed personnel have closed the road at 1 a.m.
My lord.
right?
My lord.
Definitely for the security of that. And then you have read, they have not used force.
My lord.
They say by pushing me behind. That means they were forced. She was forced to go back.
My lord.
By what procedure? By backside. They have turned and they marched backside. In that process, this particular informant was pushed behind. Where is the using of force?
My lord, one thing is there, my lord, that blunt weapon.
This is where is the question of lathi charge? She did not say.
Yes, my lord.
She did not say.
Yes, yes.
She said we.
Yes, we.
Only she got hurt.
Yes.
Where is the other person?
Yes.
Whether public will give security to the military cantonment areas?
Yes.
Whether these villages will give security?
And in the second FIR, my lord, it is said, my lord, pushing, only thela. That is clearly that is there.
See, normally wherever you go, you will see the armed personnel will always be careful with their protection.
Especially, my lord, their area, my lord,
they are always
they
confined
always
to their
respect the
area.
women, my lord. I have various seconds.
Even if you go in the national highway, You will see there are certain barricades. You have to go slow. There will be always a barricade, whether it is a police station or whether it is, they will always use it. Why? Because public cannot protect them. There are people who throw hand grenades, other bombs,
Pelting stone.
all these personnel. That is why they are allowing. Let us see the report.
And notice also issued not appear, my lord. Only one, my lord, is sketch, my lord, is regarding the road, my lord. It is there, my lord.
It is in the record.
Record, my lord. This, it is clearly shows the everything, my lord. There's a road, two road, my lord, from the.
Normally what happens, many people are using the military road. Let us assume the Satgaon road.
Yes.
It's a purely army road,
Pure army.
but people are competing
Yes.
on it.
Using it in,
Yes,
Tomorrow if they are closed,
yes.
then people.
And here, my there's alternate road is there, my lord. Alternate road,
so
my
if
lord.
you go to Satgaon, you'll see it's
Yes, my lord.
purely it's a
Occasionally-
cantonment road.
Yes.
But public are using it as if their own.
Yes,
The
I-
auto rickshaws are plying, taxis are plying, everything is plying on that road.
It is to the at the middle portion of the containment.
And my lord, there's photograph, my lord, there in the scan, my lord. It is also, my lord, they are standing only army here. This, after that, they filed this, initially some secretary filed, my lord, but it was, my lord,
just
The particular or not block, my lord.
allowed to be used and it's similar. It's not time as alternate. Route is made by the state government for carrying out proper survey of the area. That's checking. Checking will continue as either from the remain or office on this thing. Ram Kishore. Ram. Ram Kishore. আচ্ছা। Both the petitioners are on official duty.
Read the portion underlined.
My lord.
জোয়ান সকল কর্তব্যত নিয়োজিত
Yes,
আছে।
yes. দৈনিক গ্রান হল কর্তব্য নিয়োজিত হয়েছে।
Then where from the learned CSM got the information? What are the materials before the learned CSM?
At that stage, my lord.
Where is the finding in the charge sheet that there was a lathi charge and something like
Yes.
only thala?
Only খেলা এটা মানে উক্ত
Is there any
ঘটনা
mention?
Hmm.
Is there any mention in the charge sheet
no my lord.
from the reading of the charge sheet
Yes. Yes.
about lathi charge
No.
or anything
No.
excepting thala hesa?
No, yes. থানা যোৱা নহলে ঠেলা হেঁচা কৰি
So where from the magistrate got it? Where from the magistrate could come to know that they are not in duty when the
Yes.
charge sheet has said that they were in duty. Now, please come to section 254, basic.
Yeah.
Assault.
Yes. Assault or criminal force to woman with intent to outrage her modesty. Whoever assault or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty be punished in criminal force, that is
Now, what is the definition of criminal force? You'll get just before that.
my lord.
Previous page, you'll get the
Yes.
criminal force.
Yes, ma'am. Criminal force.
Read it.
Yes. Assault by criminal force. Criminal force to any person being a grave and sudden provocation will not mitigate the punishment for an offence under this act. If the provocation is sought or voluntarily provoked by the offender as an excuse for the offence. If the provocation is given by anything done in obedience to the law or by a public servant in the lawful exercise of the powers of that public servant, or if the provocation is given by anything done in the lawful exercise of the right to private defense. It public criminal Yes. Whoever intentionally uses force to any person without that person's consent in order to the committing of an offence or intending by the use of such force to cause or knowing it to be likely that the use of such force will cause injury, fear, or annoyance to the person to whom the force is used is said to use criminal force to the other. Yes. That will not come. The criminal force is, I think, not there, my lord.
Is there any mention about lucky charge?
No.
Using of
No, my lord, in the search sheet, my lord, it is clearly mentioned that he is alive. And in the second FIR also, my lord, it is the pushing only.
So that's the reason to that extent the armed personnel turn around and start marching
Yeah.
backside.
Yeah.
They did not use their hand, nothing.
Yes, madam. Is a woman.
That could have been a different action. Grabbing of various parts of the body of the women or whatever, touching various parts.
Fine.
That is not the issue. They have turned around as per that affair.
Yes.
And started marching backward.
Mm.
Right? Push them behind.
Mm.
And so there is so many lady, madam, only Utti was not, there is not.
That's
So do you think that the order of the magistrate is correct?
No, my lord. Because, my lord, the perusal of the, my lord, FIR as well as, my lord, first sheet, and, my lord, from the criminal force, my lord, that is in the CRPC, my lord.
First of all, these two petitioners were on duty.
Yes, my lord. It is clear. My
That is clear.
lord. Clear.
So official duty.
Officially.
Second, no criminal force.
Yes, ma'am.
Yes. Third,
And, my lord, the outraging of modesty, my lord, that is not touched by, but, my lord, that is no.
there is no intention to at all.
Yes, my lord.
Right? That
Yes.
is why.
Yes.
Then 323, 320.
Injury report also in the record, my lord.
When there was a Thalahasa, where there is question of voluntarily closing grievous
Yes,
heart, and there
yes,
was no grievous heart at all.
No, no grievous.
It was only simple injury.
Yes, well, simple injury. That is, the report is there. So, Lord, 320 does not apply. my lord.
Then 506 is also not there.
My lord.
What was the criminal intimidation?
Criminal in 503, my lord.
Can we read?
Yes, my lord. Whoever threatens another with any injury to his person, reputation or property, or to the person or reputation of anyone in whom that person is interested with intent to cause harm to that
Alarm,
person.
alarm.
Yes, my lord. To yes, my lord. The whole book. Or to cause that person to do any act which he is not legally bound to do, or to omit to do any act which that person is legally entitled to do, as the meaning of the meaning, avoiding that execution of such treat commit criminal intimidation.
So is it applicable?
No, my lord, no. Criminal intimidation, my lord, is apparently not there.
So what the court should do now, Mr. Sharma? Kindly tell us. Why are you laughing? You are the public prosecutor.
No, my lord, the prayer, my lord, prayer of the petition, my lord. The prayer portion, my lord. Everything is before your lordship. And this case.
Everything is before the public prosecutor.
Yes, my lord.
You are supposed to defend it.
Yes. No, my lord,
If
there is
there is
nothing.
anything.
And my lord, at this stage, my lord, nothing to defend because, my lord, everything is analyzed, my lord.
So what will be the outcome?
That order, my lord. There is, my lord, that impugn order, set aside and pass. Aru? And thereby proceeding before the civil magistrate.
Public is fairly submitted, my lord.
Where is the order of 2311?
My lord. 2311. No, no. 2311, my lord.
Is my lord
28,
20. The court orders will go.
my lord.
What Mr. Estimate? No, speak. The informants of the case. Part of this.
Only I have submitted one written argument, my lord. Only one thing, my lord, I have pointed out. When the, my lord, it is there, my lord, it will help me, your worship, my lord. My lord, when the taking.
Your written argument is of how many pages? 22 pages.
My lord, I have given some judgment of this apex court as well as this court, my lord. One thing is of the when taking cognizance, my lord, the mind of the minister should be reflected, my lord. Yeah, nothing, my lord.
Mind of the magistrate.
Yes, my lord. Why it is taking cognizance of taken, my lord? There is a judgment, my lord. I is there, my lord. Let's see, we'll pay it.
It is there, his mind is there. See, come to page number 28.
Explanation, my lord. Reason, my lord. Nothing, my lord. On perusal of the record, my lord, going through, I have found this one. In this case, I appeared in before the learned CGM test school itself, my lord. My lord, I am not allowed to argue this case also, my lord. They already made up our mind, my lord.
Something was dropped after that I have found. Something was dropped. You should have written sufficient material or something.
Before
I have found, then there is something, some words are dropped under section such and such. You read that page. The order taking cognizance. I have found, then few words are dropped. You just see. Under section such and such.
Please, please,
Such
Bharat.
cognizance taken. The last two lines.
I have found under section,
I have found, after found, something have been dropped.
under section, when so,
Likhit petition alone. Yes, next.
highly appreciated.
It will.
Worship, this matter we would like to.
Lordship.
Where is Mr. Kolika? In his absence, it will not be possible to pass this order.
But Lordship, on last occasion, he have fairly submitted that he do not have any objection.
No, but he has to be here.
Yes, Lordship, that is there, Lordship. In the morning also, he was not present, Lordship.
Find out if he is available, then we'll pass this order. So we'll fix it another day.
Lordship may kindly fix it on another date because Lordship, there is another matter in the another court, Lordship. The short date may be fixed, Lordship, on that day.
Friday?
Lordship. Interim order pass may kindly continue.
Heard Mr. P. Das, counsel for the petitioner. Petitioner. No representation on behalf of the sole respondent. In the name of the council secretary. Please take it on Friday.
Obliged, Lordship.
May it please your lordship. Lordship, these are two applications under section 482 of the CRPC for lordship quashing of the impugned order by which cognizance was taken in a complaint case against the respective petitioners without lordship prosecution sanction, and as well as the appending lordship complaint petitions. Lordship, at the motion stage itself, owing to the lack of sanction and on the prima facie materials, lordship, the complaint case pending before the learned trial court below has been stayed, my lord. Accordingly, we have taken steps, and on orders when the matter has come up, lordship, my learned friend has also filed the reply, lordship, in affidavit. On the first occasion, this has come for admission. My prayer, my lord, is this much, that these two matters, my lord, would require prolonged hearing, my lord, and matters may be admitted for hearing. In as much as, my lord, in item number 7, my lord, I have instructions to engage a senior counsel, my lord, from the client. And with regard to item number 8, my lord, he has been transferred from Silchar to Dhubri, my lord, and as such I could not obtain instruction. The matter may be fixed for hearing, my lord, and accordingly we'll conduct lordship, even if expedited hearing also, that is fine, my lord, after 3 weeks, my lord. That is my prayer, my lord. So in item number 7, I have instructions, my lord.
এটা নতুন আজি নহয়।
Records haven't been called for.
No, Lordship, record not called for, Lordship.
Records, lordship, not required, because in the petition, the documents have been annexed, your lordship.
Lordship, in this regard, may I make a small submission, my lord? My lord, because his complaint petition, CR case, has been filed as a result of, as per his allegations, is that the FIR in which the respondent number 2 has been implicated, that is a false and fabricated FIR. But lordship, surprisingly, that FIR has resulted in a charge sheet. And the police officer who has filed the charge sheet after completing thorough investigation, he is not an accused, lordship. So lordship possibly is very correct and pertinent to the extent of lower court records. And maybe lordship, the case of the parent case, where lordship, the respondent number 2 has the first genesis drawn that this is a false and fake case, then lordship, the records of PRC case number 1492 oblique 2022 may also be perused by the honorable court, my lord. That has ended in a charge sheet. I have submitted the charge sheet as well.
In that case, lordship, I am appearing and trial is going on in that case, lordship.
Doesn't matter.
And that will be
What Mr. D.K. Baidyal, learned counsel appearing for the petitioner. And Mr. K. Vaishya, learned additional public prosecutor. Going take respondent number 1. Also heard Mr. A. Shom, learned counsel for the respondent number 2. In Buddha petition, Mr. Som, you are the respondent number 2?
Yes. In both the petitions.
One or two. As it is seen from the complaint petition, of the respondent number 2, complaint petition. There are two different complaints or the same complaint?
Same
No,
complaint.
my lord, same complaint, my lord.
Complaint petition of the respondent number 2. Being complaint within bracket CR case number 126/2022. Submitted before the Chief Judicial Magistrate, Pachar Silsar, on 08/06/2022, being CR case number 126/2023, that was transferred to the Court of Learned Judicial Magistrate First Class Pachar. Who on 06/01/2023 took cognizance of the offences under sections 166 of the 211 341 oblique 342 oblique 465 and /469 IPC. Against the petitioners originated from the Dholai Police Station case number 58/2022, corresponding to GR number 750/2022. Wherein the respondent number 2 complainant is the accused number 1. In which the police, after investigation of the case, submitted the search sheet on 31/05/2022, while search sheet number 93/2022. Wherein liquid, wherein liquid search is file, in which the respondent number 1 is the search sheet accused. And that the learned judicial magistrate first class Pachar Silchar already on 29/07/2022 took cognizance of the offences under sections 120/B/420/379/411 IPC against the said respondent number 1 in PRC number 1492/2022 arising out of Dolai PS case number 58 of 2022. Pending before the court of London, JMFC Pachar Silchar. From the record of which are necessary for proper identification of this case. Call for the up-to-date record of say PRC case numbers arising out of IPS case. Scan, legible scan copy. The records. From the photo of London. Released on 2nd of September. The interim order passed earlier on
Lordship, for admission, Lordship.
28/06/2022. Shall remain in force till the next date of testing.
Lordship, in the interim order, Lordship, here two petitioners preferred the petition, but the whole proceeding state is state. The one of the accused, Lordship, he has not preferred any petition.
When the records come, we'll pass the, Mr. Shom, you just remind us on 2nd.
Lordship.
Will you make it clear?
Yes,
Only with regard to these two petitions, right? But you inform us on 2nd when the matter.
Yes, yes.
My lord, may I prefer one small accommodation? Can it be on 3rd or 5th, my lord? There's an outstation matter, as per lordship's convenience, my lord. 3rd or 5th or 6th, as per my learned friend's convenience as well, my lord.
After third,
Second, my
Lordship,
lord,
then
one
after
critical.
third, sixth, Lordship.
My lord, my lord. Very deeply obliged, my lord.
Obliging, Lordship.
May I please, Lord. We would like to withdraw this matter, Lord.
You are picking us.
Yes, Lord.
But Mr. P. K. Das, counsel for the petitioner, appellant. And Mr. K. Boissel, an additional public prosecutor appearing for the state sole respondent. The basis of an information lodged by the informant Sankar Varman Gosegaon Police Station, case number 152/2016 under section 448/326 of 307 IPC, corresponding to GR number 177/2006, 2016 was registered against the petitioner. Learned Assistant Session Judge Koprajar in Sessions case number P2 before P2/10/2018, arising out of said Gosegaon PS case number 152/2016 by judgment dated judgment and order dated 28/07/2021, convicted the appellant under section 448/324 IPC and sentenced him to undergo simple imprisonment for 6 months under section 448 IPC and simple imprisonment for 1 year under section 324 IPC, where the sentence ends to run concurrent. Agree with the said judgment of conviction and sentence dated 28/07/2021, noted above. The appellant preferred the appellant prepare an appeal before the learned session judge Koprajar, being criminal appeal number 05/2021. The learned session judge Koprajar, by its judgment dated 30/09/2023, dismissed the said appeal of the petitioner, being criminal appeal number 5/20, upholding the order of the learned assistant session judge dated 28/07/2021, passed in said session case number. Thereafter, the appellant preferred his criminal appeal against the orders of the learned session judge dated 30/09 to judgment against the judgment at 30/09/2023, passed by the petitioner, learned session judge, criminal appeal number arising out of six. During the deliberation of the matter, on instruction of the appellant Belun Roy, BELUN, son of late Penda Roy, PND, resident of village Potma Bill. Post office of police station to apply for this. Not nothing pressing this bill. Audit. Registry shall forward a copy of this order. Court with report of non-HSC. Court brother. As well as report of non-HSC. Alright.
Right.
In view of the order constituted in the connected criminal of concern. This intercurricular application. During purpose status. Task, no?
Apply.
May I please your lord? Let me this matter, scan copy of LCR was called for, my lord, which is not received, my lord.
Yes.
One last,
Where was the office number 0508-2024? MSSSGL and Council according to the. You are Miss C. Roy.
M. Deca.
M. Deca. And Standing Counsel for the Customs Department. Respondent Customs Department. By order it is all. Where is the office application? Okay. By order it is 1902 202. The registry record of CR case number 75312022. 751C. To us call for. In the court of London, judicial magistrate first class. Metro Guwahati. Forty date. Send copy of the report. Immediately received. Issue reminder to the learned for the sake of copy of the sec. Scan copy of the sec. Whatever it's more than it's about 6 months till the registry did not receive the report. Released on 9th of September. Whether on the part of the registry to receive the 11 records from the court of London. The court shall consider to pass. Consequential order at the officer. The registry shall also communicate this order to the court of London. for its list.
Highly object.
Highly object.
Can copy please.
May I please, your lordship? This matter came up before your lordship for the first time, your lordship. LCR has to be called for your lordship. Section 10 of POXO Act, your lordship. And informant is also a party, your lordship.
What's your good name?
S.A. Hussain. Prior to this, there was a condemnation of delay wherein informant appeared, your lordship.
Heard Mr. S.A. Hussain, counsel appearing for the appellant. And I must and thus additional prosecution. Appearing for the state respondent number. The judgment in order dated 10/05/2022. Passed by Learned Special Judge Advocate from Sessions case number 08/2001. Convicted the appellant under section in of the POCS sentencing him to undergo rigorous imprisonment for 5 years with fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. They agree to say judgment of conviction and sentence. Dated 10/05. The appellant. You are in jail or
Yes, lordship, I'm in jail, your lordship.
since when?
Since the date of judgment, your lordship.
The petitioner. Sorry, the appellant. Central jail.
Lordship, Central Jail, Guwahati.
Serving. Let me set the date. Call for the records. As such and such. Appellant shall take state. Response number 2 of the informant. Equally attack. Persons listed. Arising out of Jalukpadi Police Station case number 343/20. Have you annexed the copy of the FIR?
Lordship, the copy of the judgment is annexed, your lordship.
The address of the
Lordship, as at case number 2 is the address. I will indulge your Lordship.
The appellant on or before 9th of August shall serve a copy of this memo of appeal along with the annexes appended thereto to the learned public prosecutor of this High Court, obtaining necessary authority in that regard for certain notice of the respondent. In comment. Thereafter, the office of the prosecutor. But yes, no, report the officer in charge of Dharwad Police Station to the public prosecutor. It's High Court. On the next, shall submit a report regarding service of notice. List on 11th of
Lordship, the address of respondent number 2 have now changed. While condemnation of the delay, we have prayed leave from this honorable court. Honorable court has observed to take steps on the correct address, your Lordship. Thereafter, they appeared. May also observe to take steps on the correct address, your Lordship, new address.
You have given the new address.
It was not provided, orally submitted while in the condemnation of delay. This honorable court allowed, your Lordship. They appeared also, your Lordship.
Who appeared?
The respondent number 2 also appeared. While the condemnation petition was being heard, your Lordship.
Just check. Order to cut it. The number is Place this matter on Friday, reflecting the name of Mr. Nayan Jyotidas, learned counsel, for the respondent number 2, who earlier appeared for the said respondent, and the connected interlocutory application I criminal 1151 of the 2023 that was prepared by the appellant for condemnation of delay. In preparing this appeal, that was disposed of on 24/03/2023 after hearing Mr. Same counsel for the appellant. The allegation of prosecutor as well as state Mr. and the does. We'll pass this order in his.
Look.
Okay, okay. Yes, please.
May I please, my lord. Yes, I have filed the application under section 482 of CRPC for passing a impugned order passed by the Honorable Vishwanath Sariyal Session Court. The order is page number 67, my lord. The petitioner is the registered owner.
Have you gone through the record? It's a matter of NDPS case. Let's go through and then tell us.
Lordship, regarding Jima, I have to bring the report also.
This is rejection of Jima.
My lord,
What was the finding of the learned?
it's a NDPS case.
The finding
Yeah, it's
regarding rejecting the Jima. Why it was rejected by the learned?
on the ground of confiscation. But prior to that, my lord, we have applied for, we have moved the Jima application, but honorable below court, they have rejected it. They have said that it is under in the 68 page number, or it is reflected the vehicle bearing number, registration number, AS 12Z049, that is under the process of confiscation. At that time, it was not confiscated. And subsequently, we again filed a Jima application. There it has been reflected, it has been confiscated. Supporting argument, my lord, Gurvinder Singh versus the state of Punjab, the last page, that is the page number 6, 20, point number 22 is the operating, it's a operating part.
In page 68, moreover, the petitioner has sought for Jima of the Vivo mobile handset, but there is no any valid document submitted along with the petitioner claiming to be his owner. Since the vehicle bearing was confiscated and as we are upon bearing, first place. No any supportive document for the Vivo mobile handset submitted.
My left charge sheeted is on the process of trial. And the vehicle which has been seized, it is finance vehicle. Until that, I am paying the EMI, my lord. Whereas the vehicle is in the custody of police since December 22.
Lordship may call for a report.
Yes,
No, Jima report whether it is required. No.
Have you challenged that confiscation order? You have not challenged it.
No, my lord, we have not challenged.
Then
My lord, in fact, we have given a judgment of Honorable Guwahati High Court, that is Saurabh Datta versus Union of India, 2020. That copy also we have furnished. Still then, the below court, they have not considered. It has been clearly mentioned about the procedure. The point number 9 is very clearly reflected. Point number 9, it is to be mentioned here that the Honorable Supreme Court, while dealing with the releasing seized vehicle in the case of Ashok Kumar versus State of Bihar and others, bracket 2001 9 SCC 718 held, we do not think it is necessary to keep the vehicle in the compound of the court indefinitely for the very long time till the final disposal of this case. It is more advisable to ensure that it is registered on entrusted it to the registered owner on behalf of the court under certain terms and conditions. We therefore,
Deori, you have to tell us, because this particular vehicle which you are asking for, Jimma,
my lord,
has already been confiscated. That's the reason. And these judgments which you have placed, not related to such confiscated vehicle. There are two provisions, as you know.
my lord, while confiscated,
No doubt that this particular vehicle was seized during the investigation, or was seized because along with the contraband goods it was found.
my lord.
But thereafter the vehicle has been confiscated and there is a specific order. It's not
No, prior to that, it was not, they have not confiscated.
But on that
Later
day,
only they have.
true. When the matter was considered, it was already confiscated.
The fact has been revealed in the subsequent Jima application, my lord, not prior to that.
They're telling you that the date when it was, order was passed, prior to that, the vehicle was confiscated. That you are aware.
There is another judgment, Honorable Guwahati High Court in Jitendra Singh versus Unit of India in the page number, point number 5050.
Is in the case or where? In which case it has been considered, Mr. Deori?
It is Unit of India Atlant versus Jitendra Singh, son of Indrajit Singh's respondent, criminal petition 101 of 2022, decided on the 2/3/2023. Point number 26, my lord.
Of which judgment? 26 of which judgment? Jitendra Singh.
Jitendra Singh. Guwahati High Court. A conveyance is under the NDPS Act shall be reliable to be considered only when the owner of the conveyance who has given the opportunity. In this case, we are not given the opportunity, my lord.
Kindly.
Given an opportunity by the court could not be proved that the conveyance was used without his knowledge or the connivance. The court will have to decide whether the vehicle seized under the NDPS Act is liable to confiscated only on the conclusion of the trial. Now the trial is going on, not yet. Trial has not completed, my lord. Charges has been completed. Investigation is completed, my lord. And I am appearing before the court on the fixed date. The trial court has to take independent decision on the question of the confiscations, irrespective of the convictions or the acquittal or discharge record recorded by it. But at any rate, the trial court is not supposed to pass any order confiscation before the expiry of the 1 month.
Ms. Das, do one thing, go to the records
Yes, Lordship.
and tell us. Mr. Durian Monday,
My lord,
Lordship.
Tuesday, Monday, I have in the law, but I have to meet.
that's true. You are coming from Bishanath regularly?
No, whenever I have matter, I come.
Tuesday it is difficult because it's a.
Okay,
hearing.
then Monday, my lord.
No, if you have any difficulties, give us some other date, no problem. 16th,
My lord, it's okay, my lord. 16 will be better. Hello.
but Mr. Division Council appearing for the petition. And I must send out 7 additional for prosecutor appearing for the state. Pursuant to the order of the court dated 26/06/2024. Registry has already received the 11 records from the special justice DPS petitioner. May send us additional for the prosecutor is allowed to go through the reports of non-special judge. On the next day, Ms. Das applies the court
Order done.
pertaining to the
One.
confiscation of the vehicle bearing registration number AS
NDPS.
12X, right?
0.
498.
495.
What kind of vehicle?
It's I-20 only.
I-20.
Yes, ma'am. RC space number.
Yes, I have seen, sir.
Page number 144, sorry, 13.
I-20 active.
It's a Hyundai.
I-20 active.
Activa.
VT S. Hyundai vehicle. Okay. Yes, go to the records and tell us on the next date. Whether a procedure followed for confiscation was complied with.
Hello, bro.
Yes. List on लिखी है तो list on लिखी. None appeared for the petitioner on call. Even if although 2 names of the council for the petitioner have been expected. It is seen from the order sheet that last occasion on 19/05/2023, the petitioner remained unrepresented. Prior to that, on 02/08/2022, the matter was assumed in the prayer of the council. Though by order the 21/12/2016. Court called for the record of criminal division number 2 in bracket 1 numerical of 2012, as well as mixed case number 149. under section 135 KPK of the Code of Management of Telurango. But the office note dated 20/07/2022 reflects that due to non-furnishing of proper criminal revision number involved in the case, as well as non-inclusion of the year of the miscase the relevant records could not be called for. Due to non-prosecution of criminal because of conflict with criminal.
I'm appearing for item number 20, Lordship. In 19, I think, Lordship, there is a direction to take steps upon the respondent number 2, opposite party number 2.
No representation on behalf of the petitioner on criminal division petition 328 of the Deputy of the order 6. That's 6. The earlier, the previous date, 11/08/2023. The petitioner undertook to file necessary application for implement of the action to the informant of the case. That was directed to the court earlier on 31/01/2017. Office note dated 14/8/2023 reflects that the petitioner did not file any application for implement of this request. Earlier to 11/08/2023 on 24/07/2023, 17/5/2023, 19/4/2023, the petitioner remained the above acting petitioner is not to pursue this matter. This criminal investigation or not.
FCR received lordship.
The RMSS can get started counsel. Direct also. Criminal appeal number 14/2015. The court of London in that Mega as well as the records of assessment case number 144/2014 from the court of London in section that Mega. It was called for ID 4. In criminal division petition number 328 of 2014. Was already received by the registry. Where the said criminal division petition number 328 of 2001 has been dismissed today for non-prosecution. Being kept as a part of this record. As this criminal event petition and not to practice arising from the same process. Have you taken steps on the respondent?
Yes, Lordship. Kalabala, there.
Oh, Kalabanas are here, but unserved notice returned back.
Then we'll take
No addressee.
fresh steps, Lordship.
Just a minute.
Lordship. My lord, he is a police officer, Mayang police station, so through the concerned police station, Lordship. Because he may not be there.
Mr. Sharma.
My lord.
Just a minute.
I was lost by police officer, huh? No.
No point of taking steps. The informant was an SI.
Hmm.
What do you call?
Man,
They can
we
represent Lordship.
represent them.
Lordship may fix for hearing.
Purva, Gati Kabur. It is seen from the records of the case. The respondent number 2. Sub Inspector of Police serving in the who was serving at the Mayang police station at the relevant point of time in its official capacity. While the affair of the case involved in this proceeding. As such, Mr. B. Sharma and additional public prosecutor have accepted notice on behalf of the defendant. Service. This revision petition was already admitted for hearing by order dated 07/012 07/12. Registration accordingly. Please this matter for hearing. Minutes. UCL code. It is to be noted herein that distinctly bail granted to the revision petitioner. Right. About to say, that no, sir, it should not. Mohammed. First in a criminal thereby the registry shall forward a copy of this report of matters. Morning of the report of matters. Now,
Diploma.
It is to be noted herein the appellants. Sorry, represent a petition and the petition Ali, son of Janava, Mohammed Safiqul and Aaron Bait in terms of the order 07/2016. Past in a payment number of factories filed in this. It is particularly unquoted. Report. 21.
Please, your lordship. As per office note dated 26/7/24, lordship, neither record nor answer notices returned regarding respondent number 1 and 3, lordship.
There is the office note dated 26/07/2002. Matter be placed before the Lozima court. For necessary report as to whether sir notice on the respondent numbers 1 and 3 by registered post with AD issued on 0/12/2019 within degrees now placed on 28th of August. The interim order passed earlier. What is the interim order?
18/11/2019, Lordship, ordered it.
Call for the scanned copy of the records of complaint case number 2822/2019 from the Court of Lords, Chief Judicial Magistrate from eligible scan copy list from sub. Interim order passed earlier on 18/11/2019. Shall remain in force. Listing of events.
Obliged.
Mr. Sharma, have you gone through the offense report and all? Matter is stayed since 2019 January. It's not fair. It's not in 6 years, 5 years. Matter is pending with stay, proceeding has been stayed. You should look at the offense report.
Smile.
Yes,
Yeah,
regarding the involvement of the parties.
May I please, Lordship? Lordship, official dated matter 31/7/2023, madam. Due to wrong address, madam, notice could not be served, madam. But we have found, madam, address, correct address, madam.
You are appearing.
Madam, on behalf of madam, Mr. B.K. Das, madam. Madam,
See, could not take steps. The matter is against Equitel. You have filed in 2021.
madam, wrong address, madam, notice could not serve, madam.
Whose fault?
Madam,
Whose fault?
madam, we have found, madam, the correct address, madam.
Hmm. The Union of India is the counsel. Union of India is the appellant.
Madam.
So
Madam,
you cannot provide the correct address of the accused who have been already acquitted.
acquittal, madam.
Definitely.
Madam, the order, this appeal file, madam, against order of acquittal, madam.
Just a minute. Yes, you are Mr.
HP Nirmal,
You're appearing for the railways,
my lord.
right? Please come to page number 26. You should not keep these matters pending for no reason. Read.
My lord.
Got it, page 26?
My lord.
Read para 15.
In this case, Piroli one Mukesh Kumar is a gateman and sole eyewitness of the incident. Piroli two Biswajit Sharma is the SSE signal Guwahati, and the complainant of the case, Piroli three Montu Deka, is the person who came to the RPF post with accused to hand over the vehicle. Piroli four Bikul Deka is the SSE signal Guwahati in charge of the gate barrier. Period 5, Omit Kumar is the CYM Guwahati to whom the incident was informed first. Period 6, BK Yadav is the first inquiry officer, and period 7 is Ravi Kumar is the second inquiry officer who submitted the prosecution report. On the contrary, the defense did not adduce any evidence in their favor.
Now read 16. Go on reading.
Period 1 deposed that on 4/1/16 at about 26 hours while he was closing the gate barrier and was about to close the same, then the offending vehicle bearing registration number so thus into the south side barrier and damaged it, after which the driver along with the offending vehicle fled away from the spot, and he noted down the registration number of the said vehicle, which has also been mentioned in the FIR.
So as per this PW1, the occurrence was on 4th of January 2016 at around 8:26 in the evening, night. Now read para 17.
Piroli 2, who was the SSC signal Guwahati and the complainant of this case, who deposed that he arrived at the place of occurrence after happening of the incident, and on arriving saw that the south side barrier is in damaged condition. Therefore, he along with the RPF personnel jointly verified it, and after verification says the same, and after that lost the FIR.
18.
Piroli 4, who is the SSC signal Guwahati in charge, deposed that on 4/1/16 at about
8:30, 10:30, 22 hours mean 10 o'clock at night.
He got
10:30 was at night.
information from the SNT control Guwahati that an auto rickshaw does into the south side barrier of LC gate number SP 13 in between Guwahati and this railway station, due to which the state gate barrier was damaged. Therefore, he directed Sri Biswarma SSC signal East cabin Guwahati to go to the place of the occurrence and to repair the damaged gate. After verification, Mr. Sharma gave him the report for the same, and therefore he used a new signal boom for replacing the damaged one, and he entered in the ledger book regarding the instance of new bomb.
19.
As per FIR and Piroli 1, the incident took place on 4/1/16 at about 8:26 p.m. But Piroli 5 deposed that 1/1/16 while he was posted as station master at Guwahati railway station and was on duty from
2 p.m. to 10
p.m.
p.m.
to 10 p.m.
On that day.
At about
8:50 hours, that is at
he
night.
informed that the gateman as the gate number so to close the gate barrier for passing 10 number so up Rajani Express. That is as per Piroli 5. The incident took place on 1/1/16, a little before of 8:50 hours, but Piroli 1 stated that the incident took place on 4/1/16 at 8:26 hours. Piroli 6, the inquiry officer deposed that he has inquired into the case and the inquiry on 10/4/16 appeared before him with an anticipatory bail order, so he did not necessary formalities, and therefore, on being asked, the accused confessed his guilty before him, and he has recorded the confessional statement in presence of independent witnesses, namely Sri Prafulla Burman. Exhibit 14 is the confessional statement, but to prove the fact, the EU has not recorded the statement of the Prafulla Burman even produced him before the court. Therefore, Pillar 7 was re-endorsed the case to complete the investigation, and after conclusion of inquiry, finding the incident being true, submitted the offense report against the accused person. Pillar 7 also deposed that in the MBA report there was a mention of the damage to the offending vehicle.
Right, so many contradictions. First of all, the date of occurrence.
My lord.
As per the eyewitness, incident occurred on 4th of January 2016. As per the station master, who was first informed regarding the incident, he was on duty from 2 p.m. to 10 p.m. He was on duty only on 1st January. That is a contradiction he found. Then the PW6 was the inquiry officer, recorded the confessional statement of the accused in presence of an witness. But there was no statement of that witness, nor that witness was produced before the court. Then the motor vehicle inspector did not find any such damage of the offending vehicle. How will you improve your case in this appeal? What are the materials before you? When the appellate court has considered all these contradictions and accordingly set aside the judgment of the trial court. So tell us, what are the materials before you to show that these findings of the learned appellate court is bad? We'll issue notice to the accused only if we see that there are materials to set aside the appellate court order. As you know, that with regard to any such appeal against acquittal, what is to be followed. Now, these contradictions has been found by the appellate court, whether the trial court judgment will sustain. You know the outcome. See, basically, these are the chances you are appearing before the court and having a chance. You should approve, you should read. No doubt your client has asked you to file an appeal, you have prepared an appeal. The materials to show, what are the materials to overcome these contradictions?
Well, I'm fixing any other date, next, any other date, I will prepare.
What is the another date? No another date. Today is sufficient. How will you overcome these contradictions? These are in evidence. By giving another date, you will be able to improve your case. What are the grounds that you have taken? What are the grounds? No grounds. Okay, anyway. Why it should be, the appellate court order should be set aside?
Purely 1 minute, the eyewitness is there, my lord.
Do you have the position of the PW1, PW6, PW5 with you? Don't have? So Wadi Railways have preferred this appeal. Did not furnish to you. Or what? You have the depositions of PW1, PW5 and PW6. We do not have, then how do you overcome the deposition of PW1, 5 and 6? Okay.
Well,
The first attempt.
May I please, Lord?
Okay.
Both the parties settled the matter amicably on last 5th of August.
Have you filed affidavit,
Yes, Lordship, I have filed additional affidavit, Lordship,
joint affidavit?
with the settlement agreement, Lordship. Settlement agreement is there, my lord, with the additional affidavit. Lordship may kindly page 54, my lord. Paragraph 8, my lord.
Page 54.
Page 54 from additional affidavit, my lord, paragraph 8. Respondent number 2, my lord, that is myself, my lord, has taken a permanent alimony, my lord. By taking that permanent alimony, we have execute this agreement and settle the matter, my
You
lord.
don't have a page 54 here.
Additional affidavit, you have 9.
When did you file that
54,
additional affidavit?
54. It's 54. That's it. No? No.
পাহাড়ের তো
Nine.
let the respondent number 2 file an affidavit. You have a doubt? Where you have paid the permanent alimony?
5th of August, Lordship, last 5th of August.
In cash?
Yes, Lordship. Our signature is there, my lord, in agreement, and I personally identified that agreement, my lord, on 5th day of August, my lordship. May kindly peruse my signature also, my lord. Page 51, my lord.
What's your name?
Mr. S.A.B. Khabir, my lord. S.A.B. Khabir.
Mr. Kabir,
Lordship.
the person who signs a signature
Lordship.
is aware what are the name, the spelling, right?
Lordship.
Are you sure about that? Normally, he will not commit that, or she will not commit that mistake.
Definitely, my lord.
Come to page 55. Look at the signature. What are the spelling? Kindly tell us.
A-Y-E-C-H-A. That's the one.
Right?
Lordship, lordship, lordship.
And the other pages, what she has done.
Definitely, my lord. Big mistake, my lord.
That is why we had it.
Lordship, lord.
That's the reason. Right? There is another mistake. We have the
Lordship, it
records
is
before us. We
original
have
copy.
seen that you can say S or C. It
Also-
appears to be C, it might be S also. We have
Yeah.
seen that.
Original copy is there, man.
We have seen that it appears to be C, but it might be S. It might be S. We
Kindly
have
tell-
seen.
Only one time, my lord. Only.
That is the reason we have seen. That's why I'm saying we know what we have. This is before us.
Lordship. In Xerox, my lord, it looks C, my lord, but in original, it is clearly reflected.
But
my lord.
difficulty is, you know,
Lordship.
the style, the handwriting, everything changed.
Lordship.
We have seen that will not reveal from the original records will. And also from the Wakalatnama filed by her.
Lordship, lordship. I do not have any objection if your
No,
lordship
if
give her
this-
personal appearance.
We
also, my
would have considered if that amount has been deposited in her account.
Lordship.
But
Lordship may in
by
that case
saying in
give her
cash, that's the
personal
reason.
appearance also, lordship. I do not have
We will
any.
not say personal appearance, then who will identify her? Affidavit has been filed by the husband, not by her.
Yes, my lord. But agreement has been executed mutually by both of them, my lord.
That's what.
And if lordship have any doubt, my lord, I do not have any
Now, there are
objection.
reasons we will not explain.
Lordship, lordship,
We have verified from her original record.
lordship.
Record is before us. Her signature doesn't tell you the Wakalatnama. We are not investigating officers, of course, but at the same time, we can
Definitely.
always have doubt because
Definitely, my lord.
she is not before us
Lordship.
straight away. And the matter relates to alimony. Of course, we said, had it been deposited in her account, we have nothing to talk.
Lordship.
But you have paid in cash. File a joint petition. Consider. List after 3 weeks and the meanwhile, after the 5th, both the petitioner and respondent shall file a joint petition pertaining to the agreement executed by them on zero 0508 2022. Also regarding the permanent alimony of rupees 1 50 paid to the restaurant number 2 by cash in cash by
Obliged, my lord.
May I finish my lordship? Lordship, escape was taken as per last order dated
22/2023, service report is awaited.
Respondent number 2 has changed his home 4 to 5 years back. He is no longer available in this, under this police station. So, respondent number 1, right?
Yes, sir. One.
Publication of notice in the newspaper.
Okay.
That's all. Where is the office number? Dated 31/07/2024. As per the report of the officer in charge of this police station, that the respondent number 1 Timothy Runjun Bora, resident of Santi Plaza, SHA, flat number T-4, Komazati Asylum, have left the said place 4 to 5 years back. And no one in the vicinity are aware where she went in her present place of stay. It is also seen the Learned Chief Judicial Magistrate Kamrup Metro, Guwahati, reported that the process server, after visiting the place as per the address provided, did not find the respondent number 1 who left the said flat long back and residing some other place not known to the people of the people residing nearby. On the prayer of the council for the petition, applicant, on the prayer of the council for the applicant, he is allowed to take steps for service of notice on the respondent number 1 by newspaper publications in 2 widely circulated newspapers in the state of Assam, one of which shall be to the register of this court, one of which shall be in English, and the other the vernacular Assamese. Such successively completed by the petitioner applicant / petitioner applicant. on or before 30/08/2024. Placed on 6th of September. In the meanwhile, the applicant shall file an additional affidavit enclosing the copies in original of the newspapers in which notice submitted with a notice on the respondent number 1 shall be published without of this order. Please record.
Obliged.
It please, Your Lordship. As per office note dated 5th of August 2024, my lord, neither the credit card nor the answer notice has been received back by the registry, my lord.
Lordship, in item number 26, I am the amicus curiae. I have not received the paper book, Lordship.
Mr. Sharma, get the report from the officer in charge of Dolamura Police Station, Karbi. By order dated 9/8/2023, court directed to take steps on the respondent number 2 to the officer in charge of Dolamura Police Station, Karbi Anglong. Office note dated 5/8/24 reflects that neither the service report nor the answer notice have been received back by the registry. Matter be placed before the Lodhima Court forthwith for service of notice regarding the report of service of notice. Next. Mr. B. Sharma, an additional public prosecutor, on the next date fixed, shall also apprise the court the intimation from the officer in charge of the Dolamura Police Station regarding service of notice. Oximeter.
Yes.
Oximeter.
Agar order to us, list on 2nd of September. In the meanwhile, the appellant to the public prosecutor of this high court shall take step on the respondent number 2 in its report address by serving a copy of this memo of appeal along with the annexes on or before 9th of August. Thereafter, the office of the public prosecutor party to the officer in charge of Dolamura Police Station shall serve copy on the respondent number 2. That's informant of the case relating to Deepu Police Station case number 272/2018. The officer in charge of Dolamura Police Station shall according on the next date fixed to the officer in the public prosecutor to Guwahati High Court shall apply the court regarding service of notice. Copy of it. Next, in 6, there are 2 accused or what?
2 accused, my lord, in 25-1, another in 26.
MS D. Seychelles and Amicus Curie have entered appearance on behalf of the accused appellant, convicted accused appellant, who is in jail custody serving sentence.
Dolama.
Pursuant to the judgment in order of conviction dated 0209-2022, caused by learned special judge Supreme Bracket Pokso Cardian in Pokso case number 06-20. Registry shall furnish the copy of the judgment of the learned trial court. I so case number 0209. Operating at placed on submit along with criminal appeal. Ms. Saikia, you can go to the record.
Deeply obliged, Lordship.
None appeared for the appellant on call. The order sheet reveals that even on last occasion, I on 20-02-2023, when the matter was taken up for consideration, the appellant remained unrepresented. The percentage to be given no names of two counsels have been reflected in the court case. Okay, okay. Name of counsel. Placed on 16th. Burua. And full name. Ipo Maranayana. Number. Two four double two eight nine.
In item 29, my lord, I have a prayer, my lord. For objection filing, my lord, our learned PP, my lord, S.H. Boda, my lord, second the file, my lord. So he will file it shortly, my lord.
Give us a
Kindly,
date.
my lord. On 17, my
Since
lord.
October 2023, could not file your objection. Why?
Kindly give short date, my lord, in next week. Also, my lord,
Not October,
will
since
accommodate,
November 2022.
my lord.
What is this, Mr.? Person is in jail. Since when you are in custody?
Lordship, since the date of judgment, Lordship, and order, Lordship,
What is the length of punishment?
10 years, Lordship.
10 years. Okay, since September 2022, 23, 20. During trial,
Trial, he was in custody for 3 months, Lord. Thereafter, he was released.
okay, Notice been served on it. This is a POXO matter.
Lordship, in this case, amicus curiae appointed. Notice served.
Yes, madam. D.
and-
Gogoi. D. Gogoi.
You are there. D. Gogoi.
D. Gogoi, my lord.
Amicus curiae absent. Or Mr. L. R. Mazumdar, counsel appearing for the appellant applicant. Mr. B. Sharma, learned additional public prosecutor. Appearing for the state respondent number 1. Prays for some time to file objection. With regard to the suspension of the sentence imposed upon the appellant applicant by judgment dated 30/09/2022 passed by London Special Judge in bracket POXO Kasar Silsar in special POXO case number 66 of 2019. POXO bracket okay. None appeared for the amicus curiae appearing for the respondent number 2 informant remain did not appear in the matter. Okay. Though his name has been reflected in the court list. It is seen that even on earlier occasions, the state was granted time to file its objection to the matter. Placed on 22nd, the state shall file its objection if any on or before 20/08.
Like. My lord, this, our appeal was for interim compensation with 2 LCR, sorry, LC. Now that case has been disposed of with conviction of the accused. And so we do not want to pursue the matter. That order sheet is with me of the LC.
What's your good name?
PK Kolita.
Counsel for the petitioner. And Mr. P. Sharma, learned additional public prosecutor appearing for the state respondent. The petitioner, Deepen Sharma, DWIPA, SARMA, son of late Gopal Sharma, filed this criminal petition on 29/09/2022. Praying amongst others to set aside the order dated 20/03/2021 passed by
SDGM 1.
Learned Subdivisional Judicial Magistrate within the Charter number 1, Kamrup Metro, Guwahati, in a complaint petition being CR case number 6295 C 2018, filed by him Filed by the respondent number 1. Convicting him under one 38, whereby he was directed to deposit 20% of the total amount of the set. That is 60,000. Out of it is honored check amount of 3 lakh. Thereafter, the petitioner agree with its order from the learned SDGM as number 1 preferred a criminal preferred a revision petition being criminal revision number 20 of the 2021. Whereby the learned additional session class number 2 dismissed the said revision petition of the petitioner. Mr. Collegial Learned Counsel appearing for the petitioner by placing the order detection 01072024 passed by learned sub-criminal judicial magistrate one Kamrup Metro NCR case number 6295 of 2018. Have finally disposed of submitted that they have finally disposed of the said complaint case, whereby the petitioner has been convicted under section 138 of the NI Act and sentenced him to undergo simple imprisonment for a period of 6 months and to pay compensation up to 6 lakhs. As fine, comma, in default to pay such fine as compensation. Sentencing him further to undergo simple release for another period of 3 months. However, on the prayer of the petitioner, he was allowed to remain on previous bail for a period of how many days?
My lordship,
Enabling him to prepare an appeal. What happened on 1st of August?
nothing.
Did you prepare an appeal?
No, they have appealed. Opposite party.
You are appealing for whom?
Complainant. Petitioner.
None appeared for the petitioner. What to do? You cannot close it in presence of the accordingly, but this not in presence. Should not pass. That's information to be taken. Burwa. Fixed on 19. You are fixing it on 19. Today you are not disposing of more, only just recording you.
Yeah. Hey, item number 42.
Item number 22 15 hours.
এতিয়া এই মেটাৰ বিলাক কেতিয়া আহিব?
Almost done. Yeah.